Welcome to the Copeland Coaching Podcast, where it's all about turning your job search into a slam dunk. Your host is Angela Copeland.
Welcome to the Copeland Coaching Podcast. I'm your host, Angela Copeland. Live in the studio with me today, I have Jim Simpson in Memphis, Tennessee. Jim is one of the founding partners of the Allen Summers Law Firm. He has over 20 years of experience practicing law. Jim's practice focuses on business litigation, commercial disputes, employment law, labor law, and many other areas of civil litigation. Jim, thanks for joining me today.
Oh, I'm glad to be here, Angela.
Well, I'm very excited about this. I work with clients, as I mentioned to you before we started, I work with clients at all stages of their career, from just starting out all the way to C-level leadership. And I found that many of my clients are accepting job offers verbally. So, I think the advice you're going to provide today is just going to be fantastic. But in terms of folks that are out there accepting job offers verbally rather than in writing, do you have any advice for them?
Absolutely.
Okay.
It's always better to get your job offer in writing because it avoids any misinterpretation about what the initial terms of the employment are going to be with your new employer. Mm-hmm. Most employers don't have a problem with reducing what the initial job offer is to writing. Mm-hmm. If you're in a situation where you're just given a verbal job offer, mm-hmm. you could actually change your position based upon that verbal offer and still have a legal basis if, for example, the offer was revoked mm-hmm. after you resigned from or terminated your current employment. But there could be a big question about what the terms of that job were supposed to be. By having something in writing, you can work out the details on the front end. Mm-hmm. In addition, a written job offer can kind of give you a launching pad mm-hmm. to additional terms that you might want to talk about with the employer and perhaps even respond in writing to concerning how you envision your new employment relationship should be structured.
Right.
And it's a lot easier to do that from a written job proposal mm-hmm. than it is from just a verbal offer. A verbal offer is a good start,
right?
But I wouldn't use that as my jumping off point from telling my current employer that I'm leaving.
Right, absolutely. I think there's a lot of opportunity for miscommunication when things are just done verbally. When you said that there's an opportunity, if it's not in writing, for the job to change, do you mean sort of the job description or what the job is? What do you mean?
Well, usually an initial employment offer is vague in terms of its terms. Mm-hmm. It will say, we're going to offer you X position at Y amount of money, and your duties are going to be Z. Mm-hmm. Okay? Well, that job offer is basically a job offer for employment at will.
Right.
And you could accept that job offer, go to work for that new employer, things not work out for a very long period of time, or over a very short period of time, and the employer could decide that you're just not working out.
Okay.
You might want to use the job offer as an opportunity to try to nail down what are the duties of this position, mm-hmm. and what are my expectations going to be, mm-hmm. and what's the timetable going to be for me to meet those expectations. And even better, can I get an agreement from the new employer that I'm going to have this job for at least this period of time mm-hmm. in order to prove that I can meet the expectations for the duties for which I'm being hired?
That's great. I think this would be especially useful, too, if you have, if it's a new position, because I've noticed many times when companies create a new position, they don't always have a really great idea of what it is that they want you to do or how they're going to judge your success.
Right.
So really getting them to communicate that with you right up front, is very helpful. So when we do get our job offer in writing, What kinds of details would you recommend? You mentioned a little bit hashing out the position, but what other things?
Well, I'd like to know to whom I'm going to be reporting, because many times when you receive a new job offer for a new position with a new employer, you will have interviewed with the person who you expect to be reporting. And that's all well and good, but I would want that in my job offer, because I have seen this happen many times over the course of my career, where a person is hired for a certain position. They're a very good candidate for the new employer. They have a great relationship and are very comfortable with the person with whom they're interviewing, who they believe is the person to whom they're going to be reporting, only to find out that when they are actually hired, they are not reporting to that person. They're reporting to the person who reports to that person, or perhaps the person that reports to the person who reports to the person that they were comfortable with. And that layering in management, that misinterpretation as to whom they're going to be working with primarily, is not always so good. You know, and things may not work out, and the relationships may not be as fluid as were anticipated on the front end. So when you nail down in a job offer who you're going to be reporting to, then when you get there and they tell you you're going to be reporting to somebody else, you would know that you're going to have some work to do on the front end to make sure you can build a relationship with that new person. In addition, if you get a job offer and you learn through the job offer that you're not going to be reporting to the person to whom you thought you'd be reporting, you may want to interview that other person with who you're going to be working. And before you agree to accept employment, you might suggest to the signatory on the job offer that you'd like to have an opportunity to sit down and talk to whoever that manager might be, and make sure you're comfortable with them. Because you're making a big decision. If you're already in an incumbent position with another employer, you want to make sure that you're going to be comfortable with whoever it is that you might be reporting. And that's a good opportunity to get that nailed down.
You know, I'm smiling. The folks who are listening can't see that, but ironically, I didn't expect you to have that piece of advice, but that has actually happened to me twice, personally. Once when I was coming out of college, and a new person was put into place just before I started. And the second time, I was a director at a company, and when I started, on my second day, the vice president who hired me, who I'd had a relationship with for over a year and had gotten to know him through this process, on my second day, he put in his notice that he was leaving. And, you know, you just kind of roll with it, but it certainly would be good to know that.
Absolutely. And that's another reason to ask for, if you can get it, some type of an employment agreement as to an initial term of employment that you're going to be more or less guaranteed to have an opportunity to prove your worth to the new employer. Because just like the example you just mentioned, I've seen that happen many times. And sometimes the new manager who's brought in a supervisory role is not the easiest person to work with. And hence your employment experience is not what you anticipated. And you as a new employee may not like the new manager, but even worse, the new manager may not like you.
That's right.
And if that's the case, you are out on a limb. If you don't have some type of an agreement for employment for at least an initial term, you're an employee at will, and that basically means you can be let go for a good reason, a bad reason, or a reason that's morally wrong. In virtually every state, unless the reason that they let you go is independently illegal.
Right.
So it's nice to have these things worked out on the front end, And a lot of this is a matter of bargaining power.
Right.
The more valuable you appear to be to the prospective employer, the better deal you can get on the front end.
Right.
Okay? Once you're there, once they have you there, you've lost a lot of bargaining power because you have already changed your position. You have already opted to go with them, and you're now dependent upon them for a job. Before you accept and change your position, you can always tell them no thanks. So the more valuable you are, the better deal you can get. Now, let's say the position that you're trying to get is a stretch position, a position that is maybe at a level that you're not quite ready for. You need to play your bargaining power carefully because you don't have the bargaining power that a person who is more valuable for the position might have.
Right.
So it's a fluid situation. What one person could get is not necessarily what another person could get at the job offer, negotiation, employment contract stage.
I totally agree. And I think it's important, if someone has to evaluate the level of risk that they're comfortable with as they go into this process. Someone who, say, is unemployed and maybe has children, they may not be able to negotiate as aggressively as someone who does not have a lot of personal responsibilities and who currently has a great job. If you don't need that job, it's a lot easier to sort of ask for more, than if you don't.
Absolutely.
Some of the other things that I often encourage folks to document in their offer letter is, of course, the amount of money they'll be making, any kind of bonus compensation, and any kind of vacation. Is there anything beyond that and the duties that you would really stress that we should consider?
Well, I would want to know what benefits are available, what the benefits package is. In addition to vacation, is there some type of a pension or profit sharing plan? What type of policies does the employer have? And it's not inappropriate to ask for a copy of the employment handbook or personnel manual so you can see what those policies are. For things that may arise throughout your employment. Does the company practice what's known as an open door policy, for example, where if you have an issue, you can go talk to somebody above the level of your supervisor without any fear of some sort of reprisal. And a lot of that information would be found in an employee handbook or a personnel manual.
Okay.
The more details you can get nailed down on the front end, the better position that you're in. Now, the other thing is, you want to, and I know this is not an interviewing skills
No, go ahead.
session, but when you go into that interview, you want to know as much about that new employer and the person that you are interviewing with as you possibly can. And the sources to get that information these days are immense. You can find out so much about a company just by doing basic Google searches, internet searches, and the same with individuals. You can find out a lot about individuals, likes, dislikes, their history, what their employment background has been. A lot of that information is available through sources, including social media, much of which is available publicly. So I'd suggest, when you go into that interview, to appear as a interested and more qualified candidate, be as prepared as you can.
Absolutely. Absolutely. I think oftentimes the success that you'll have at a job isn't just dependent on the job description, that you're looking at. It's often dependent on the company and the person you'll be working with and the team you'll be working, around. And so doing all that research is really important. It's critical to having a successful experience.
It's part of your due diligence, basically. Like if you were buying a new company, you would want to do everything you can to find out what it is you're buying. Entering into an employment situation in a high-level capacity is the same thing. You're buying into that company.
Right,
Now, you're not writing them a check for their assets or for their stock, but you're investing a portion of your life with them.
That's right.
So
as we go through this process and we're interviewing and we're getting closer to an offer, eventually, we get the offer verbally and then maybe in writing. At what point do we go back to our current employer and let them know, put in our notice that we've received another offer and that we, will be departing?
Well, I wouldn't suggest that anyone do that until they have accepted the offer with the new employer and they're sure they want to make that decision. The caveat to that is you want to make sure that you give your former employer as much notice as you can. Depending upon the position that you have, I would work that out with the new employer, the prospective employer on the front end, that if the position that you hold is something that's going to require 2 weeks notice to 6 months notice, you make sure that you have that type of leeway built into whatever that employment offer is, so that you can give as much notice as reasonably possible. Now, there's no guarantee that your current employer is going to want you to work for whatever notice period you offer or for any notice period at all. A lot of times once they hear that you're not committed long term, they make a determination that it might just be better for you to leave immediately. And there's nothing wrong with that, but you're not leaving them in a lurch. You never want to burn bridges because you never know what might happen in the future.
That's right.
And I'll give you an example, and I've seen this happen several times. Employee leaves company X to go work with company Y. And they leave on bad terms. And then company X purchases company Y. And employee is now working with the same people and basically the same company that they have burned bridges with.
Wow, that's an interesting scenario.
And it happens more than you might think. So what goes around comes around in life. Don't ever burn bridges. Do whatever you can to leave on good terms.
That's great advice. That's really great advice. And I think you're right in terms of the timing. The timing is critical. I knew someone once at a previous job that went and told her manager, hey, I'm looking for a job, while she was interviewing. I think thinking that she was going to be in some strong position to negotiate a higher pay or something like that. And they literally walked her out of the building that day. And she didn't actually have a job offer. And so she was just suddenly totally unemployed. Right. And, if she just thought about it a little longer, that would not have happened.
Exactly.
Well, I know there sometimes comes a time in job seekers' careers when it is a good idea to reach out to someone like you that's an attorney and ask for your advice. At what point in your mind does that become necessary? When should we start to do that?
That's a very good question. It depends on a variety of factors. And I'll just give you some of the most obvious times that it would be good advice to seek at counsel. For one thing, if you're going to get a employment contract with your new employer, you definitely want to seek advice of counsel to help you with the negotiation and the drafting of the contract. Usually what an employer would do is provide you with the employment contract, which a lot of them will have language in there that says, consult with an attorney before you sign this.
Okay.
you definitely want to consult with an attorney. Now, the attorney doesn't have to take an adversarial role with your new employer, and that's not what you want the attorney to do. But you want to make sure that somebody is looking out for your interests. Depending upon the terms of an employment contract, one of the things that is fairly common is an agreement if you leave the new employer not to compete with the new employer, a covenant not to compete provision, or a restriction on whom you could do business with if you left that employer, or customers that you couldn't call on if you left that employer. If you receive an employment contract that has those types of provisions, you definitely want to consult with an attorney before you sign it, because in most states, those agreements, if they're reasonable, they're enforceable.
Okay.
And the fact that you sign it at the inception of your new employment is many times adequate consideration to enforce those agreements and those covenants not to compete or customer restrictions when it comes time to leave. And most new employees, when they're wrapped up in the euphoria of getting their dream job, they sign that contract without thinking about what the potential consequences might be if things don't work out.
Right.
And I've seen situations where valued employees have gotten a job that they considered a dream job, signed a non-compete with the new employer, brought their own customers, their own book of business to that new employer, only to have things not work out, and then try to leave and go either off on their own in business for themselves or to a competing employer, and to take that book of business that they brought with them in the first place, only to find out they have a problem on their hands.
Right. So
consulting with an attorney about situations like that is vital, and you really need to do that, on the front end. Another reason to consult an attorney is, even if you don't get a formal employment contract, if you're getting a job offer based on certain representations and you're going to materially change your position, for example, move from one state to another.
Yes.
You want to make sure that the state that you're moving to has law that is favorable for protecting someone who changes their position and moves from one state to another based on promises or representations. So that's another reason to consult with an attorney, on the front end. And if you have a job offer that has language in it that you don't understand, or you're unclear about, or you just want clarification on, find an attorney. Call the attorney. It's worth the money to spend for an initial consultation to find out what the contract might mean, or what the offer might mean, and what the legal implications of it may be.
That's just what I was about to say. So often I think people are either intimidated with the idea of speaking with an attorney, or they're afraid about the cost. And when you consider, the cost that you'll make, or the money that you'll make annually at your new job, the cost of a consultation or a meeting with an attorney, it's very small as compared to that. And it really could help you protect yourself, understand things more. And it sounds like the new company may not even be aware that you have this attorney that you're talking to, but they're there to kind of be your advocate, be the person in your ear to kind of guide you.
Absolutely.
Yeah, I think that's excellent, because so often, we turn to friends or loved ones who really don't have truly the expertise in this area. But, the thing that's great, even just right now talking with you, is that you've probably seen hundreds of situations. So the examples that you're giving us are from years of experience, seeing the things that go wrong and knowing how to sort of navigate those waters.
You're exactly right. At the initial hiring state, you're in a position to anticipate the train wreck before it happens. And most times, such as when there's a bad parting between an employee and an employer, the damage has already been done. The train wreck has occurred. And that's when the employee goes to seek advice of counsel to find out, what can I do to put the pieces back together? And a lot of times, the broken pieces might have been avoided had you taken a proactive step on the front end and put some things in place to try to protect yourself before the damage occurs.
Absolutely. So as we're going through this whole job seeking process and we, receive an offer, one question I often get is many of the clients that I work with, they're actually afraid to negotiate the salary. And I'd love to kind of get your feedback. I know, especially in your role, you probably negotiate on a regular basis. What is sort of your feedback on folks that are wondering whether or not it's appropriate to negotiate?
Well, this gets back to what we talked about a little bit earlier, and that's just bargaining power. The more bargaining power you have in terms of what your potential worth is to the new employer, the better position you're in to ask for more salary. If you're unemployed, desperate for a job, you don't have as much bargaining power. But if you're in a high-level position to begin with at a high salary, you certainly are in a position to bargain. Now, the other thing to keep in mind is if you have a salary history with a long-term employer and you're being recruited to go work for another employer,
yes,
you're giving up a lot to risk the unknown. So there's value to that. And that's something you should feel free to talk to the prospective employer about. I've got X amount of years of goodwill built up where I am. And here's what my salary is, and here's what my likely salary progression would be. Here's what my potential bonus structure is where I am. You're going to have to make it worth my while for me to take the risk, new employer, to jump off something that is very comfortable for me.
Right.
And change to something that, and I know the new employer is telling you all the things that you want to hear. Well, you want to be comforted by it. A high salary, unemployment contract, certain guarantees, a great bonus program, pension and profit sharing. All of those things are the types of things that make that risk maybe a little bit more worthwhile.
That's right. That's right. And I think it's important to pay attention to those things. I once had an employer that was sending me flowers to my house to try to get me to take a job offer. And that doesn't make me feel better.
Absolutely.
I want things in writing. I want, the best offer possible, not presents.
Right.
So one question I also get is, if I negotiate, is there a chance that the employer might take the offer away? And typically what I tell people is that as long as you're very professional in your negotiation, typically the employer may say, no, I'm sorry, we're unable to do that for you. And then you get to make the decision. Do you take the offer as it stands, or do you leave? Would you agree with that, or do you feel...
I do agree with that, but I would err on the side of not being greedy.
Sure.
I would err on the side of being reasonable.
Yes.
And in your approach, being objective as to what your worth is and what your request is. You don't, like I said before, you don't want to burn any bridges through this interview. And you also want to make the new employer feel like the offer that they've prepared is very generous. And you're very intrigued by it. But if you're in a strong bargaining position with a great job to begin with, you want to let the employer understand what you're giving up. And that's what I would focus upon. I would focus upon the security and protection that you have already, that you're giving up to go with something new and unknown. And I think if you phrase it that way, that's a professional way to try to ask for more. But there's always a risk that the new employer says, never mind. I've seen that happen before. Mm-hmm. And you know what? If that happens, maybe that's not where you wanted to work to begin with.
That's right.
So
I totally agree with that. Well, another key time when it seems like an attorney would be really helpful is when it comes to separating from a company. And sometimes, especially here in Memphis, we've had a number of companies like FedEx, for example, and a couple of other big companies that kind of due to changes within the business, they've offered separation agreements for, employees who wanted to volunteer to leave. Aside from that, are there other scenarios when separation agreements come up?
There are, but I would advise. I would just say it's a good practice that whenever an employee is involuntarily let go, that they take their separation agreement and go seek the advice of counsel and talk to a lawyer about it.
So I was wondering about that because, I've never personally experienced it, but I hear that sometimes when you're involuntarily let go, you're not aware that it's coming. Maybe you're called into an office and you're kind of told about it. And then it's almost like you're given the paperwork right then and you're expected to sign it right then.
Right.
I mean, what should someone do if they find themselves in that situation?
Well, I from experience, I can tell you that that paperwork that usually comes with the promise of some amount of severance is going to be linked to a promise or contract that you're not going to sue the employer for wrongful termination or a variety of employment laws in exchange for the receipt of that severance. There are certain claims, age discrimination claims, that require, in order for the release to be binding under federal law, that an employee be given certain protections in any severance agreement. In any case where an employee is being asked to waive legal rights involving claims of age discrimination, an employer has to give the employee 21 days to review the agreement and consider it, and then after they sign it, 7 days to revoke it.
Okay.
And the agreement specifically advises the employee, it has to by law, to seek advice of counsel so that they understand what the ramifications are of signing that agreement. And here's why it's important from the employee standpoint. Employment laws can be very complicated. They can be very complex. And the context in which a separation agreement or severance agreement is offered many times is linked to something that has happened at work with regard to that employee.
Okay.
And that something may have to do with whether that employee has some legal claim against the employer.
Oh, interesting. Okay.
And by taking that settlement agreement or severance agreement or separation agreement, whatever you want to call it, and going and sitting down with an experienced employment lawyer, and there's lots of them out there. One of the first questions they'll ask is, what happened at your job? And I can't tell you how many times that I have had people who have come to me to review a separation agreement who, in the context of reviewing it, we have found out that they were wrongfully terminated.
Oh, wow.
And that they had a legal claim that they would otherwise be giving up if they signed that agreement. And that legal claim may be worth a lot more than what the severance or benefit is offered to get them to sign away their legal rights. So it's very, very important to do that. If you're ever being asked to waive claims as part of an employment termination, you need to go sit down and talk to a lawyer.
So how does the lawyer help you? Will they review the agreement with you? Will they?
They'll do a number of things. Let me just tell you what I would do.
Sure.
I would review the agreement to begin with, and then I would meet with the employee, and I would find out what happened. What happened to them at work? And I've seen lots of things happen. For example, I have seen someone who was a great performer who was just terminated one day, and it just happened that was very close in time after someone in a supervisory position within the company had made unwanted sexual advances toward that employee.
Oh, wow.
Okay? So it was a questionable situation to begin with. I have seen situations where an employee who was a good performer was let go with little or no notice and offered a severance agreement within a relatively short period of time of being told that they needed to retire, that they were too old to do the job. I've seen that happen. I have seen an employee who was given a severance agreement and told, and was a good performer, and with little or no notice asked to waive rights, who just happened to get that severance agreement after he had complained that he didn't like the racial slurs that were being used by his supervisor.
Wow.
So that, when you find out what happened, that gives you an opportunity to counsel the employee about whether it's in their best interest from a legal standpoint to sign the agreement. I can tell them what the agreement means. I can tell them what the legal impact of the agreement is going to be. And then I can talk to them about whether the alternative to signing the agreement as written is better for them than signing the agreement. And then once you do that, you have to make a determination, well, what's the next approach? Do you want to negotiate and try to ask for a better severance deal and bring to the attention of the company what you believe the reasons for the termination are? Do you want to do that and try that approach? That's one approach. The other approach might be to say, well, thanks, but no thanks, and just pursue legal claims against them.
Right.
So all of those things enter into the thought processes and making a determination as to whether a severance agreement or separation agreement is in the best interest of a departing employee.
Well, I think that's really helpful. I appreciate you kind of walking us through that process. I know even within my own family, I have family members that are older who were very nervous to seek legal counsel for another type of issue because they'd never worked with a lawyer before, and they pictured that it was going to be really scary. And when they finally met with the lawyer, they were so relieved because here's a person that's helping you and kind of coaching you, guiding you, that's really on your side, and it's not the scary experience that they maybe were picturing from TV or somewhere.
Right.
So.
Right. And the flip side's out there too.
Right, for sure.
I gave you some examples. There are other employees that I have talked to them about their situation and gone over their severance agreement. And the best thing that they could possibly do is sign that severance agreement and be thankful that they got something.
That's right.
Okay.
Absolutely. Well, so we've covered a lot of areas, but one last question, are there any key times when you notice that employees actually make mistakes going through the process, whether it's, on the front end when they accept the offer, whether it's when they leave? Where are those key mistakes that they should be seeking out counsel? There are several times. The hiring process, the termination process, and another time would be in the performance evaluation process. A lot of times you have employees that have been historically good performers who end up with a new supervisor, and then inexplicably their performance, which has been just fine for years, is suddenly being questioned, and they're being placed under scrutiny
for the way they're doing their job or their performance in their jobs. And in some situations, they're even put on, what I'd call a PIP or performance improvement plan, and told, if you don't do X, Y, and Z, you're going to be terminated. Kind of get better or else. That's a good time to go talk to an employment lawyer before you're actually terminated, because a lot of times you can see the writing on the wall before the actual termination meeting. So all of those times would be good times. If you were given a pay cut, if an employee was given a pay cut or was suddenly stripped of their duties and responsibilities, any time a material adverse thing happens during the employment situation, that would be a good time to go talk to an employer, a labor lawyer, an employment lawyer.
I totally agree. I think this has been great. We've covered a lot of things. Is there any other last advice before we wrap up that you'd like to offer to our listeners?
I guess the last thing I would say is, the employment relationship is a lot like a marriage. It's a symbiotic relationship. Both sides depend upon the other, and just like in a marriage, you would want to behave in a certain manner. You would want to do that throughout your employment, from the marriage or hiring, throughout the term of the marriage, and through the divorce or termination of employment. Try to conduct yourself in as professional and objective manner as you possibly can. You don't want to take the low road. It's never in your best interest throughout that situation.
I totally agree that this is great advice. Jim, if anybody is interested to reach out to you, what is the best way to get in touch?
Well, one way is of course to call us here at the Allen Summers Law Firm, 901-763-4200. We're available on the web, of course, allensummers.com, and then my email address, jsimpson@allensummers.com, JSIMPSON at Allen, ALLENSUMMERS.com.
Great. And what states do you practice in?
I'm licensed in Tennessee, Mississippi, Arkansas, and New York.
Okay.
But I've handled cases in a variety of other states as well, through affiliation or association with other firms and lawyers who would act as local counsel for us in those states. And we have other attorneys here in my firm that are licensed in other states also. So.
Okay, excellent. Well, Jim, this has been super helpful. Thank you so much.
Thank you. I very much enjoyed it, Angela.
And thanks everyone for listening. Tune in next week for another edition of the Copeland Coaching Podcast. And if you haven't already, please be sure to subscribe on iTunes or Stitcher to make sure that you never miss an episode.
Thank you for listening to the Copeland Coaching Podcast today with your host, Angela Copeland. Tune in next time to get more great tips on turning your job search into a slam dunk.